So I chose to do the case of Illinois versus Rodriguez. This case was decided by the Supreme Court in 1990. So a little background on this case. Gail Fisher and Edward Rodriguez were at once in a dating relationship with each other. A domestic altercation occurred in which police responded to the call made by Miss Fisher. Upon arrival, she told the police that Mr. Rodriguez had committed the offense of battery against her and directed them towards his apartment using the words "our apartment" throughout the process, and possessing a key to the residence. She also stated that she had her own property located within that apartment. Upon arrival to Mr. Rodriguez's residence, Miss Fisher unlocked the door with the key that she had and allowed the officers to enter the premises. The police entered and found illegal drugs and paraphernalia inside the apartment. At this time, Mr. Rodriguez was asleep when the entry was made, but was arrested for possession of a controlled substance and with the intent to deliver. Mr. Rodriguez later claimed that his Fourth Amendment right was violated as he did not consent to the search. Mr. Rodriguez filed a motion to suppress the evidence that was obtained in the violation of his rights, which ended up being the illegal substances and the paraphernalia. The trial courts agreed and granted his motion to suppress, making it harder for the prosecution to prosecute him without any evidence. The state appealed the lower court's decision, and the appellate court affirmed the lower court's decision, stating that a violation had occurred. It was later appealed to the Supreme Court for review, and the decision was made 6-3, reversing the lower court's decision. Justice Scalia wrote the opinion that reversed the lower court's decision, finding in favor of the government and against Mr. Rodriguez. He argued in his opinion that the police acted in good faith in believing that Miss Fisher had authority to consent to the search. The first question that arose was whether a police officer's good faith reliance on a party's apparent consent to search the residence as was that an exception to the Fourth Amendment, and the answer is yes. A police officer's good faith reliance. If a police officer believes that they have authority to search, then they are acting in good faith. The second question was whether or not Miss Fisher had authority to consent to the search, and that answer is no. The Supreme Court quoted Schneckloth versus Bustamante, a case where the court decided that a voluntary search can be determined from the totality of the circumstances and does not require a knowing and intelligent waiver of constitutional rights. Because Mr. Rodriguez argued that he did not consent, the Supreme Court used this case saying that it does not require a knowing and intelligent waiver. Another legal principle which was argued was that of the exclusionary rule, but the court argued that the Fourth Amendment does not guarantee that no government search of his house will occur unless he consents, but rather that no search will occur that is unreasonable. And they determined that the search of Mr. Rodriguez's apartment was indeed reasonable. The dissent was written by Justice Thurgood Marshall, who stated that the police cannot ignore a person's Fourth Amendment right when they did not consent to the search of the premises. Him, along with, I believe, two other justices, joined him in the dissent and also reminded the court that warrantless searches were tolerated for the purpose of exigent circumstances that would require an officer of the law to conduct a warrantless search for their safety and for the safety of the community. They had determined that this case did not meet the threshold of exigent circumstances as no one was in imminent danger. The differences between the majority and the dissent are pretty obvious. Obviously, the majority believed that the Fourth Amendment right was not violated, and the dissent says it was. The majority argued that it was not a violation of the Fourth Amendment right because police acted in good faith and reasonably believed that Mrs. Fisher had authority to consent, whereas the dissent argues that because Mr. Rodriguez didn't consent, it was in violation, and furthermore stated that a warrantless search should be executed only under exigent circumstances. It's hard to determine what the consequences and possible precedents would be of this case, but it does allow the government greater reach when it comes to search and seizures. It also limits the Fourth Amendment right to many individuals who may fall victim to the government's belief that a search was considered reasonable by third-party consent. So I guess it takes away rights from defendants and gives more rights to the government, in my opinion. Now, after I just said that, while I do agree that it does give the government more rights, I also believe that the police in this, I think each case needs to be judged particularly on their circumstances, and in regards to this case, I do believe that the police acted in good faith. Because Ms. Fisher did possess a key, she did state that she had property in the apartment, and she was referring it to our apartment throughout. It's hard for police to determine to decide that she wasn't authorized to give consent when she was stating everything to the contrary. I do agree with the Supreme Court's decision. Again, I think going forward, every case needs to be judged based on their circumstances in the totality to decide whether or not a warrantless search is in violation of the individual's Fourth Amendment rights. Thanks for watching.